Maria, do you want to start?
I'm ready.
All right, excellent. Because we don't have a court reporter today, we're doing AI transcript. So we can start whenever everyone's ready. Is everyone ready? Looks like they are. All right. Let's get on the record. Today is September 25th, 2025. This is the second regular docket in the OCD month, and we hear status conferences today. And we'll start off with a Goodnight Midstream Permian case 24491. Entries, please.
Adam Rankin appearing on behalf of Goodnight Midstream Permian with the Santa Fe office of Holland and Hart.
Dana Hardy with Hardy McLean on behalf of Empire, New Mexico.
Is that all?
I think that's all in this one.
I thought Sharon Shaheen might be on this one
Oh.
too.
You want to enter?
No? Oh, there
That's
is an
okay.
entry for Spencer Fain representing Empire also.
Sharon Shaheen, Spencer Fain, also representing Empire.
Thank you. All right, so Mr. Rankin, this case has been on stay for about a year now, waiting for the outcome of the battle between the Titans before the commission. That battle is, I guess, well, a final order has been entered, let's just say that. So how do you want to proceed?
Thank you, Mr. Hearing Officer. This is a narrow issue in this case about whether or not there's good cause for extension of a injection authority. I believe that the issues in this case are not affected by the order or ruling in the commission order to the extent that that order is not even dispositive of the issues in that case, I don't think. So my request is that this case go forward on the merits to determine whether or not there's good cause. And I think given the potential outcome of the commission case, this well has even more importance. If it turns out that those 4 wells are shut in immediately or time incrementally, that'll be a loss of over 100,000 barrels of produced water, affecting more than 30,000 barrels of oil production a day. And it will have a grave impact on the state. So the additional capacity that this well will provide is important.
Okay, thank you. Ms. Hardy?
Yes, Mr. Examiner. So this well is the subject of one of Empire's applications to revoke the permit. And that application was filed in case 24021. And that application was transferred to the commission, and then it was stayed because this well is close to the unit, but right outside of it. So Goodnight had argued over Empire's objection that the cases for involving wells outside the unit should be stayed, pending the determination on the wells inside the unit. So the application to revoke is pending before the commission and is stayed. So given that fact, I think this case has to also continue to be stayed because I think whether there's good cause for the extension is impacted by whether the permit should be revoked completely, which is still not been decided.
Ms. Shaheen, do you have anything to add to that argument?
I do not.
Okay, Mr. Rankin, I'll give you a chance to respond.
Sure. This well is more than a mile outside the unit. The findings of the commission and the order determine that there is no impairment at present, even from the wells inside the unit. So I think in terms of what the impact is on this particular application, I would, if in fact Empire intends to pursue or request that a stay be continued, I think they should file a motion to articulate the bases under the Tenneco standards for doing so. Again, it's a narrow issue on whether or not there's good cause to go for to extend the order. I think that's the scope of the hearing, and to the extent Empire can make a showing based on that it should be continued to be stayed, then I think we can have that argument. But at this point, I ask that the case be set for a hearing so that we can go forward to get our extension entered.
It's a tricky one. It's a tricky one because we have an application to revoke the authority, but that application is now at the commission and it's been stayed.
At Goodnight's request.
At Goodnight's request. Right. No,
Yeah.
and thank you. Yes. But we have an amendment case depending on good cause. And even if the division found good cause to extend the injection authority and the well is more than 1 mile outside this ROZ that Empire was the center of Empire's case before the commission. And Mr. Rankin, are you saying that the commission, that the order, and I'll come to you in just a moment, Ms. Hardy. Are you saying that the order handed down by the commission, which I have not read, does not deal with wells outside? What is the zone called?
The area in which the case was addressed was the EMSU, the Eunice Monument South unit. So the limitation of the order was within the bounds of that unit, addressing only the 4 wells operated by Goodnight and the 5, I think, that were proposed new drills.
And you say that because it says that in the order?
That was the limitation of the scope of the hearing.
It was?
Yeah.
Ms. Hardy?
So well, I disagree with Mr. Rankin's interpretation of the order. I think it found that there is a violation of correlative rights, and the order was to prevent waste. Mr. Rankin is correct that the order does not deal with wells within the unit. I mean, I'm sorry, the opposite. It does not deal with wells outside of the unit because those applications are stayed, including Goodnight's application to inject into this well. And once the order issues are resolved before the commission, there's a rehearing deadline coming up next week that the parties would file for motion for rehearing, and then there would be an appeal. But in any event, following a decision on the motions for rehearing, Empire will file to proceed with these additional applications that are at the commission regarding wells outside of the unit.
The applications to revoke?
Yes.
Well, I'm really what I'm trying to decide is there a legal basis to move forward with this amendment case? That's really what I'm focused on right now, not about the commission. Now, we have an order from the commission. Ostensibly, we put this application on stay until we got an order. We do have an order. Whether or not it's appealed or the subject of a motion to rehear, you wouldn't be filing a motion to rehear, would you?
Not on the results overall. There may be specific items.
Right, because you want it, basically.
Basically, yes.
Right. And Mr. Rankin, you would be filing a motion for a rehearing?
We will be.
Okay, you will be. Okay, all right, sounds good. And I know they're working on the record for eventual appeal, so they know that's coming as well. So that's in the works, so that it's done efficiently. Does it go to a district court or does it go to the Court of Appeals?
It goes to the district court.
District court. Is that a Rule 74 or 75 appeal?
I believe it's 74.
So is it mandatory or is it
mandatory?
Oh, it is mandatory. Okay, 74 is mandatory. All right.
Mr. Hearing Officer, I may just make a comment about procedural issues here and the consideration. So 2 things. One, just to be good, since you haven't read the order, I just want to make clear that
Since I haven't what?
read the order.
I have not read the order.
I'm going to make clear two key findings.
Yes.
Okay. Number 1, the commission found that Empire's correlative rights are not currently impaired. Okay, number 1. Okay, and that's under their finding paragraph 3C. The commission found Empire did not adduce substantial evidence that the correlative rights in the Grayburg are currently impaired by Goodnight's injection into the San Andreas. They also found that the proposed ROZ is not recoverable. There's been no proof that it's capable of being recovered either in the Grayburg or the San Andreas. So the key findings about impairment and correlative rights were determined not to favor Empire at this time. This is more than a mile away. By allowing this case to go forward and having us have a hearing on the narrow issue of good cause, in the event that we prevail, which I think we have established a clear basis for a good cause to extend the order. We would have then an order in place an effective valid order for injection, it would then be incumbent on Empire to file a motion to stay that pending review by the commission, in which case they would need to establish the bases to stay a validly issued division order. So I would proffer to the division that rather than circumvent those legal hurdles that Empire would otherwise have to establish, we'll be allowed to go to hearing, make our case on good cause, get an order favoring Goodnight's continued valid authority to inject under that well, and then require Empire to make a showing for why it should be stayed.
Ms. Hardy?
I think that all of that is premature and unnecessary. I think that the application's been filed. So at this point, I think it should be stayed. I don't think the Tenneco factors apply to a stay of proceedings. They apply to a stay of an order. At the very least, I would think it might make sense for the division to set this for another status conference in another month after the rehearing motions have been filed and Empire has had an opportunity to file or reinstate, not reinstate, but seek to lift the stay before the commission on its application to revoke this specific permit.
I'm not sure I don't know anything about technical factors and how they apply to this. And I'll ask you in just a moment, but here's the logic that I'm using. And it's favoring Mr. Rankin's argument to hear the case because I stayed this case before the division instead of, and I think there was a motion to refer this case to the commission, which I rejected because I felt like we can deal with the amendment ourselves in the division level. So Ms. Hardy, the logic I see here, and tell me where I'm going wrong, is that we stayed this pending the outcome of a final order. We have a final order. The final order is restricted, from what I understand, and I could be wrong, but is restricted to the EMSU and not outside the EMSU. It would seem to me that if you wanted the commission to expand that order to outside the EMSU, I think you'd have to provide additional evidence to the commission to show how that's justified, let's just say. So based on just those simple facts right here, and not even dealing with the two key facts that Mr. Or so-called key facts that Mr. Rankin just told me, that are in the order, which I don't see even that it impacts what I'm doing here today. It seems to me logical to remove the stay, have the hearing on good cause, and if the division finds good cause, then you have a way to block that order at the commission level.
Well, the fact that I agree that we would need to present additional evidence at the commission, but we would do that by lifting the stay there on the application to revoke the permit for this well.
Right.
So I don't think that it's consistent for Goodnight to have argued that the applications at the commission involving the wells outside of the unit had to be stayed, and then argue that this case should go forward. I think when there's an application pending to revoke this specific permit, it's not appropriate to proceed with a decision on extending injection into their injection authority into this well.
I mean, even if that application to revoke were at the division level, which I think it was at one time, and
Yes.
then it got referred as a group.
Yes.
Would you remind me? Is that correct?
I think that's right. I think all of the cases were referred to the commission other than this
Right.
one.
Right. But didn't this one come after those?
I think so.
I thought so. I seem to remember that.
Yes.
Or else I think I would have referred this to the commission, but it came after. And then I felt like it was an issue that we could deal with. And then if Empire didn't like it, they could deal with it at the commission level. It just, I understand your argument, but I don't hear anything that makes me feel differently, that the original reason why we did this is X, and now we have X, so we should proceed. And then there are remedies for you at the commission level. Because I think even if your application to revoke the authority were at the division level, we could consolidate that and hear that together at the division level along with but if I'm not mistaken, we really, this is a very narrow issue, as Mr. Rankin says, that this is about good cause. That's the way we've dealt with other amendments as just we want to hear good cause only. So I'm not even sure we would consolidate it, or maybe I don't know. That's outside the scope of what we're dealing with today. So I'm gonna remove the stay. Mr. Rankin, would you draft an order removing the stay, moving this case forward? When do you want this case heard?
May I confer with my client about their availability and maybe to do so, Mr. Hearing Officer, would you maybe provide available dates?
I have them here on a piece of paper.
Okay.
So we have 4 left for the rest of the year. Okay. Now, I don't think we need, well, I think we do need a technical examiner for a good cause, because maybe something would come up. Maybe Ms. Hardy would raise an issue during the good cause that a technical examiner would need to look at. So we have October 14, that'd be virtual only. We have October 28, also virtual only. And then we have November 18. It would be on a trailing docket.
Okay.
And then the last of the year will be December 9. So those are your 4 dates.
And December 9th would be in person.
It would be. So with the November, right, Freya?
Yes, that's right.
Okay, so November and December are in person. The 2 October dates are virtual.
Okay. With permission, Mr. Hearing Officer, I would
Mhm.
confer with the client to determine availability.
Sure. I also have to make sure that Ms. Hardy is available as well.
I would do that. I should be able to get answers today, I expect.
Will you communicate with Empire's counsel?
I will.
And let us know what is decided
I will.
between the parties?
I will.
Yes.
Okay, excellent. Do you anticipate having witnesses?
I'll have to consult with my client. I think they may want to have
Okay.
witnesses.
And
I
that's
mean, I think, yeah,
Yeah, and that's fine.
Yeah.
And we are limiting it to good cause.
understood.
Okay. I mean, we've done that in the past, and I think that's only fair because that's what the rule permits as a reason to amend. And we are working, Ms. Vance, on a notice for, when you need to have a hearing for amendments and when you don't. You've been talking about that with John Garcia, and I just thought I'd mention that now to you. It's in the works, and I think it'll come out soon, along with some other notices that I'll talk about in just a moment. But Mr. Rankin, is there anything else?
Nothing on this matter that I can think of, Mr. Hearing Officer. Thank you.
Ms. Hardy?
The only other thing I might suggest, but it's not been done at this point, would be to refer this one to the commission so it'd be consolidated with the other applications regarding the wells outside of the unit.
I thought about that.
Yeah,
As we were talking earlier, and I still think that this is an issue that the division can simply rule on based on a narrow issue of good cause, and then let the parties handle it from there. I think you have multiple options on how to deal with this once it gets out of the division, and that it wouldn't prejudice you or your client for us to hear this, and so that's how I'm thinking about this.
Okay.
So if there's nothing else on this, I will mention that we have some other notices that are coming out in the next short time frame. Number one is, I think it's called a request for a hearing. Applicants have in the past had a simple procedure to request a hearing. That procedure will become a little bit more elaborate coming up. It'll require more data entry from the part of the applicant so that the division is relieved of making any type of errors that we might make in trying to guess what the application is really asking for. So you might mention that to your paralegals or whoever does your data entry if it's not you yourself. In smaller firms, I get it. I'm just saying. So that's coming out. We also will have the notice as to when you need to have a hearing for an amendment and when you don't. I know that's been a subject of issue lately, especially after Dylan's notice last year. There's one other issue that's coming up too, and it escapes my mind. So what I'll do is I'll move on to another case and it'll come to my mind. Okay, so we're off the record in 24491. And we will set a hearing for good cause based on Mr. Rankin and Ms. Hardy's conversations with their clients. Okay, I'm now calling Spur Energy 25535. Entries, please.
Dana Hardy with Hardy McLean on behalf of Spur Energy Partners.
Thank you.
Sharon Shaheen on behalf of Longfellow Energy.
Who?
Longfellow Energy.
Longfellow, thank you.
Carrie Hatley entering her appearance on behalf of ConocoPhillips.
Thank you.
Good morning, Mr. Hearing Officer. Miguel Swaza with Beatty and Wozniak appearing on behalf of Riley Permian for monitoring purposes only.
Good morning. Monitoring only. Okay. And Ms. Hatley, did you tell me what your position is?
I did not. I apologize. I will rectify that in the remaining cases today. I am monitoring only in this
Monitoring.
case.
Thank you. So does that mean, Ms. Shaheen, are you the one who objected?
Yes, I believe so. And Longfellow has sent out well proposals and will be filing applications. I think the first available docket will be the December 4th. The well proposals went out on the 16th of September.
And it's the 9th, just to be clear.
Oh, is it December 9th?
It is. Yes, I didn't say the 4th. It was the 9th.
Okay, my bad.
No, it's fine. But does that still make sense to you?
That does, because
Okay.
I don't think we could make the November docket.
That sounds fine. Okay. That's why I mentioned all four. Ms. Hardy, it's your case.
Yes, Mr. Examiner, and I think Longfellow and Spur are talking, but at this point, I think it makes sense to set a contested hearing on the December date that's available.
December 9th. Okay, so I think it's a Tuesday, right, Freya?
Yes.
Okay, very good. And if it needs to go longer, it can go into the Wednesday or Thursday after. It's fine. We're here. Okay. Ms. Hardy, do you know what the issues are between Longfellow and Spur? Okay.
I don't, other than competing development plans.
Right.
I don't know how the plans will differ,
Okay.
or if they will differ, I don't know.
Okay.
I can
Did-
summarize a little bit.
That'd be great. Thanks.
Yes, Longfellow actually is the current operator in that same area for wells that are in a different formation. In
Okay.
fact, they're called the Marley wells.
What wells?
They're called the Marley wells, which
Marley?
is the name of the Spur proposed development.
Okay.
So that is one of the issues. Longfellow believes it should be operating these wells because it is already operating wells in a nearby formation, I believe in the Yeso formation.
Okay.
But I don't know yet the availability of my witnesses, so I don't know if they're available on that December 9th date.
Okay. Well, they can appear virtually, as you know. And they don't have to appear here. And do you know what the interest ownership is between the difference between Spur and Longfellow?
That I don't know offhand.
Okay, and you don't either.
I don't either.
Okay. You don't know Spur's interest in
I don't think
Okay.
I do. I
Okay.
think there was an objection before we had the
I see the
exhibits.
data. Okay.
Yes.
All right, perfect. So we'll set this up. We'll issue a pre-hearing order for December 9, and Ms. Shaheen, you'll let us know if your witnesses are not available.
I will.
Yes, thank you. And is there anything else, Ms. Hardy?
No, thank you.
Ms. Shaheen?
Not for me, thank
We're
you.
off the record in that case. Let's move on to Select Water Solutions. There are 5 cases. We have joined them together for the purposes of a hearing. 25545, 46, 47, 48, 49. Entries, please.
Dana Hardy with Hardy McLean on behalf of Select Water Solutions.
Thank you.
Carrie Hatley entering her appearance on behalf of COG Operating, and we are objecting.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Devon Energy Production, and we entered in an appearance and objected as well.
Now, I'll ask you, Ms. Hatley, in just a moment, but Ms. Vance, do you object to all 5 applications?
That's correct.
You do, okay. And Ms. Hatley, all 5?
All 5.
Okay, 5.
Mr. Examiner, Matthias Sayer, representing EOG resources in this matter. We entered an appearance in 25549, and similarly are objecting.
Oh, very good. Thank you.
And
Now,
good morning, Mr. Examiner. This is Dina Bennett appearing virtually. My apologies for not being there in person. But I am going to be entering an appearance in case 25545 on behalf of Coterra Energy Operating, and they object to the case moving forward.
Thank you. I can't hear you. At least I couldn't hear you like I could hear them.
Mr. Hearing
I can hear
Examiner,
you now.
Gabrielle Gerhold on behalf of Civitas Permian Operating, we have filed an objection in case 25549.
Thank you. So let me go around the room virtually and ask, what is the basis of the objection? Because I doubt that anyone is going to be presenting a competing plan here. So Ms. Vance, you have the microphone. What is your objection?
So basically, we're just, my understanding is that Devon and Select are working on an accommodation agreement. And the parties did meet, and I already conferred with Ms. Hardy on this, but our request, Devon's request, is that we do another follow-up status conference. I will say, you know, it sounds like the meeting between the parties went really well. So we're just working towards an agreement right now.
What's an accommodation? What is that?
So basically, since where Select is planning their development, and again, Ms. Hardy can correct me if I'm wrong, but essentially, where they are proposing to put their disposal wells or the injection zones, it may be closer near to where there's development for operators such as Devon, and so there, you know, it's disposal is a necessity for operations, but so just something that works out for both the parties.
Okay, that makes sense. Thank you, Ms. Vance. Can you pass the microphone to Ms. Gerhold since she's next to you? And what is your objection?
Mr. Hearing Examiner, our objection is the potential impact on the Avalon Formation in our future development. We also hope to come to an agreement with Select.
By having them move their wells a little bit here or there?
I believe that's the path we're going to pursue.
Perfect, thank you. Ms. Hatley?
We are working an agreement with Select. And if we do, if we reach it, we will withdraw our objection. We are generally supportive of disposal opportunities, but we're very cautious as to how and where and how much.
So it's the how and where. Okay, thank you, Ms. Hatley. Mr. Sayer?
Thank you, Mr. Hearing Examiner. My client has a well within the AOR for the well proposed in 25549.
You called it an EOR?
AOR, sorry, the
AOR.
area
I
of
didn't hear
review.
you.
Apologies.
An area of
Review.
Thank you. Thank you, Mr. Sayer. And Ms. Bennett?
Thank you, Mr. Hearing Examiner. Coterra Energy Operating also does have a well within a half mile of the proposed, or unit within half mile of the Coyote Fed 14 SWD number 1, and so has concerns about the impacts of injection on Coterra's existing wells. And Coterra only recently received notice of this proposed SWD. It was originally sent to Franklin Mountain Energy, and then Coterra only recently found out about it. So I can't say whether they've been in discussions with Select yet, because they just found out about this well very recently.
Perfect. Thank you, Ms. Bennett. And I hope you feel better, by the way. I know you've been sick for a while. It seems like you've been sick for a little while now. Ms. Hardy?
Yeah, thank you.
Thank you. Ms. Hardy?
The parties are in discussions with Select. I think Select is working with them to try to resolve these issues. I don't know, as Ms. Bennett mentioned, if they've talked to Coterra, since that's a new entry. But our plan was to request another status conference on the 2nd October docket in the hope that some of these issues have been resolved,
Okay.
or at least we know whether they will be.
Okay. And that makes a lot of sense to me. I'm going to do two things. I'm going to set, well, I'm going to set a status conference for these cases on the October 28th docket, but I'm also going to set a hearing on the 11/18 docket. It's a special docket. The 11/18 hearing docket will have a technical examiner who specializes in injection wells. It'll be Mr. Anthony Harris. And he's only available 2 days for the rest of the year. And that was the October 28, which sounds like it'll be too soon for you, and the 11/18, which sounds just about right. So that will issue a pre-hearing order for the 11/18. If for some reason your witnesses are not available on 11/18, please let me know. They can appear virtually if you so choose. Is there anything further on these cases?
No, thank you.
All right, perfect. From any other party? All right, excellent. All right, we're off the record in those 5 cases. Let's move on to one of Mr. Bruce's cases, which I don't know that he'll be here for, but this is 25562 and 25564. Entries, please.
Good morning,
Mr.
Mr. Hearing. Go ahead,
This is
Mr.
Jim
Bruce.
Bruce. I am available, Mr. Examiner.
I hear.
from the
Thank you.
parking lot of the Director's office.
Thank you.
Good morning,
Mr.
Mr.
Savage?
Hearing. Yes, good morning, Mr. Hearing Examiner Darren Savage with Aberdeen Shield, appearing on behalf of Katerra Energy Operating Company.
Okay.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, Contra Oil and Gas, Marathon Oil Permian, and Mongoose Minerals, monitoring only.
Thank you. Okay, Mr. Savage, you obviously objected because what, you have a competing application?
Yes, sir. This is a contested hearing that originated from the creation of the Wolf Phone pool and updated applications.
Yes.
So,
Okay, how do you want to proceed?
well, I think we need to set a contested hearing date.
So I've given you, I don't know if you've heard, but I announced 4 different possibilities for the rest of the year. Do you have one in mind?
Yes, Mr. Bruce and I conferred, and I believe the November 18th would be at this time, the preferable one.
Perfect. That's what we will do. We'll issue a pre-hearing order for 11/18. Question, Mr. Savage, how many witnesses do you think you'll have?
So it would be similar to the OCC hearing. So that would be 4.
Okay. Yeah, I listened. I was there for most of that 2-day hearing that occurred, and hopefully we won't be in a conference room for one of them.
Yes.
Yeah. All right. So about four witnesses. And Mr. Bruce, from your party?
Mr. Examiner, probably 2 witnesses, and just as an aside, Mr. Savage and I have been working together to minimize what would be presented at the hearing, and I think we're not looking forward to a day-long hearing. It would be much shorter than that, and I believe Mr. Savage would agree with that.
Okay. And I think you would put that in your pre-hearing statement, wouldn't you?
Oh, absolutely, sir.
All right. And same with you, Mr. Savage, you'd narrow the issues in your pre-hearing statement?
Yes, we would certainly try to streamline this.
That'd be great, because I do read those. They're very helpful, especially when they're clear. Okay, we'll issue a pre-hearing order for 11/18. That will be in person, but your witnesses, of course, can attend virtually if they want to. So anything further, Mr. Bruce?
No, sir. Thank you.
Good luck with your eye surgery. Mr. Savage?
Yes, and I believe that covers also the next case in this on the docket, what we just discussed.
Aha. So I called 2 cases, 25562 and 25564. Is there another case?
No, just those are the 2.
Okay, excellent. Well, thank you, Mr. Savage. We'll be off the record in those cases then. Okay, let's move on to Permian Resources. Let's see. It looks like there's a few cases here. 255, 67, 68, 69, and 70. Entries, please.
Yes, Jackie McLean with Hardy McLean on behalf of Permian Resources.
Good morning.
Good morning.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Oxy USA.
Good morning.
And we have entered an appearance and objected to all of these cases.
Perfect. The basis of your objection is what?
So Oxy just received proposals, AFEs, and is reviewing and would like to just have some opportunity to negotiate with Permian. I know Permian would like to move forward, but I will go ahead and say we'd like to request that they push to a second status conference. We feel confident that hopefully the parties can come to an agreement by that point.
Feel confident that they can hopefully.
Yeah. Yeah, I had to, I started to say that and then I was like, I got to add a qualifier in there. So hopefully, I guess I can narrow it down to hopefully. Hey, it's almost Friday, okay? It's been a long, last week was a long week.
Thank you, Ms. Vance. Okay, Ms. McLean, I give preference to the applicant and what they want. So
Yes.
What do you want?
Well, to motivate them to come to an agreement, I would like to request the October 28th contested hearing docket.
Okay, that sounds good. We'll issue a pre-hearing order for October 28th. And Ms. Vance, obviously, if you guys come to an agreement in principle and you haven't papered it up, file a motion, we'll turn it to a status conference and we'll go from there.
Sounds good. Thank
So
you.
you have motivation.
Yes, yeah.
Thank you, Ms. McLean.
Thank you.
We're off the record in those cases. All right, so let's move on now. It looks like to Mewburn oil cases. It's 25594 and 25599.
Dana Hardy on behalf of Mewburn.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of ConocoPhillips and Mongoose.
Okay, and your position?
And we have entered an appearance and objected, and there are two other Red Hills cases that we just filed an entry of appearance and objection to. I will go ahead and let you know that we're planning on filing competing applications, and we'll be filing that for the November 13th docket.
I didn't understand when you said there are two other Red Hill cases. What did you talk to me about?
Let me pull up the case numbers. We just filed that yesterday because Conoco Mongoose, they just received those applications. And I can give you, if you give me one moment, I can give you.
So you're saying there's two other Mewburn Red Hill cases that are not on the docket?
Yes, that's correct. Well, they're not on the docket today.
Right.
So those case numbers are 25638 and 25641. And it's my understanding that they are also Red Hills applications.
And Red Hills is just a well name, isn't it?
Yes. Mhm.
Okay.
Yeah.
And are you, okay, so are you saying that your client, ConocoPhillips and Mongoose Minerals together?
Yeah, they're
Okay.
they're, under the same umbrella for COG entities.
Got it. So are you saying that they're going to be filing competing applications to all four cases?
I haven't looked at everything, but my understanding is yes, something along those lines, that they will directly compete with all four of those cases.
And when do you plan on sending out well proposals?
It's my understanding those have gone out and we are planning on filing the applications for the November 13th docket, which is why I would request that we go ahead and set another status conference, but of course we would like to perfect notice.
Right.
So possibly for the November status conference, that way we are done with notice at that point.
Yeah, and maybe a December hearing.
Yes.
Okay. Ms. Hardy?
Mr. Examiner, I think that another status conference would be fine on the November docket, but I think I would request that the cases be set for contested hearing on the December docket that's available.
Fine. But can we resolve these case numbers too? Or is she correct when she says 25638 and 41?
That's correct. Those are the other two Red Hills cases, and those are currently set on the October status conference docket because ConocoPhillips objected.
Okay. Why were they, so when the two cases that are on our docket today, 94 and 99, when were they filed?
Those were filed in August.
Oh, okay. Why were two cases filed in August and two cases filed much more recently?
just the timing of the well proposals and the filing dates,
But is it all part of one plan?
they're separate sections that are being developed.
Okay.
So
Separate
they have the same name,
Oh.
but the acreage is different.
Okay.
Yes.
Would it be appropriate to consolidate them?
I think they could be consolidated.
Would you like us to?
Sure.
Okay, so Freya, will you consolidate 256, 38, and 41 with these two cases?
Yes.
All right, excellent. And then Ms. Vance, when do you anticipate filing?
We're going to file for the November 13th. And I understand Ms. Hardy would like to set the contested hearing for December. But I would like an opportunity to confer with my client to make sure our witnesses would be available for that time before committing to a date.
Sure. But, all right, so we'll issue a pre-hearing order for December 9, and if it doesn't work for some reason, you'll let us know. And we can be flexible by a day or so this way or that. And then Ms. Hardy, are you going to continue your cases to what other docket for a status conference?
I think it would be the later November docket. That would make sense
They're
to
all
me.
together.
Yeah, that way we filed perfected notice and then we can consolidate the cases under an amended pre-hearing order.
That's fine. Yes.
That works for us too. Will you file a motion to consolidate when you do file your cases? I don't know, how many will there be? Do you know?
4.
Oh, there will be 4. So 4 competing with 4. So when you file your 4 cases, would you file a motion to amend the pre-hearing order to add those cases?
Would it be possible, because I just recently did this and I don't remember what cases it was with Miss Bennett, but I went ahead in the application and just requested that
Fine.
that way it saves the filing.
And when you say in the application, is that something Freya will see?
Yes, I'll make sure that I follow up with Freya so that she knows there's reference to the pre-hearing order, and I just request that it be consolidated and set for the pre-hearing or the contested hearing.
That works too. You don't have to file a motion. That works too. Ms. Hardy, anything further?
No, thank you.
No? All right. All right. So we're off the record in those 2 cases. Now we're going to move on to our last 2 cases of the day, it looks like. 25595, 25596, Matador Production. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Matador Production.
Thank you.
Jackie McLean with Hardy McLean on behalf of Permian Resources.
Thank you.
Sharon Shaheen on behalf of Elephant Cone Properties and estate of Kenneth G. Cone. And I'll note that we did receive a well proposal and are in the process of negotiating a lease. And at this time, we're simply monitoring to preserve our rights.
Perfect. Thank you. And Ms. McLean, what is your position?
We have objected to
You've
both
objected.
cases.
Okay. And is that all the parties?
I think there's another entry, Kotera.
Yeah.
Yes, good morning, Mr. Examiner. Dina Bennett on behalf of Kotera Energy Operating and Magnum Hunter and Cimarex Energy. And we did object to case 25596. And yesterday I filed an entry of appearance and objection in case 25595. So Kotera objects to both cases moving forward, and Kotera is planning on submitting competing applications.
Okay, perfect. And when you say, so where are you in the process of filing the competing applications?
Yes, so Kotera did send out well proposals in September, but they were inaccurate, unfortunately. So Kotera is working on revising the well proposals even as we speak. But what that means is that under the division's rules, I would be filing for the December 4th docket, which then would allow us to go to a contested hearing if one's necessary on December 9th.
Okay, perfect. All right. Thank you very much. That's helpful. Ms. Vance?
Yes, so my understanding is there's obviously, we've got a couple of objections here, and what we would like to do is do another status conference if possible, and hold off on setting any kind of contested hearing until the parties have had an opportunity to touch base and maybe have some discussions. So right now, we'd like to do another status conference.
All right, so a status conference in October?
That would work.
Okay, and then, so that would be on the second docket. I'm not sure what the date. Freya, when is the second docket in October?
It's the 23rd.
23rd. Okay, and then at that point, Ms. Vance, I'll let you know that for me will be the final status conference, and it'll be up to you to either have the hearing on the 9th of December or explain why you can't have the hearing on the 9th of September.
Okay.
Ms. McLean, what was you objected, didn't you?
Yes,
Okay.
and we also sent out well proposals on October 20th. We're fine with status conference with the understanding that that December 9th contested hearing date is out there.
Perfect. All right, excellent. So then there'll be 3 competing proposals to deal with. Ms. Vance, do you have any idea how much of an interest Matador holds in this area?
I do not,
Okay.
not off the top of my
I
head.
thought you might. You never know. Okay. Anything further, Ms. Vance?
Nothing from me.
Okay. So, Ms. McLean, when you do file, you haven't filed them yet, your competing application,
No.
right? Okay. When you do file them, would you, I guess in the application process, you're able to signal to Freya to consolidate the cases with these 2?
Okay.
Okay, good. Excellent. And is it 2 cases? Do you know?
I am not
Okay.
sure yet.
All right. And Ms. Bennett, if you would do the same thing when you do file your cases, please let Freya know that they compete with these 2 Matador cases and to consolidate them.
Yes, I will do that. Thank you.
All right, perfect. Well, thank you. If there's nothing further,
Oh,
then
Mr. Hearing Examiner,
sorry, Ms. Bennett.
just to confirm, so we're having a status conference on the second docket in October?
October 23rd.
Okay. And then a pre-hearing order is going to be issued for December 9th?
Not yet. We're going to hold
Okay.
off on October 23rd. It'll be in my notes that will be the final status conference on these competing cases, and that I'm looking to set them for the 9th, but I'm not going to issue because it sounds like maybe we're going to have some sort of resolution according to Ms. Vance.
Hopefully. I had to do it. Mic drop. The hearing's over, right?
Anything further, Ms. Bennett?
No, nothing further from me. Thank you.
All right, thank you.
Thank you.
All right, thank you. We're off the record.
Thank you.
And that concludes today's hearing.